Hello and welcome. And thank you very much for joining me yet again in Katiba Reflections with me, Charles Nyachae. As I have had occasion to observe in some of the previous sessions that we have had on these reflections, the 2010 Constitution of Kenya very much its architecture and its content very much reflects the history of our country and the framers of the Constitution on behalf of the people of Kenya in writing the Constitution sought to directly address issues that had time and again risen during the previous almost 50 years since independence, and to write what the former constitution had been unable to do. One of the areas that for those many years in that period that was recognized as being very problematic for our nation is the whole area around leadership and governance. And it's no surprise, therefore, that there is this chapter in the Constitution of Kenya 2010, that is chapter 6, which is headed Leadership and Integrity. And today, I would like us to reflect on this chapter. It's a short chapter, one of the shortest chapters in the 2010 Constitution, and that perhaps might give the wrong impression as to its importance or significance. It's short, but there's a lot in it, and I consider it to be a very significant chapter in the Constitution, as it provides for and addresses the issue of the leadership that the people of Kenya want and the style of governance that they expect. Chapter 6 of the Constitution primarily focuses on a category of leaders who in the Constitution are described as state officers. So it's important at the onset that we appreciate what is a state officer for the purposes of Chapter 6 and generally for the purposes of the Constitution. And for this, we look at Article 260 of the Constitution, which is the article that has definitions. And that Article 260 defines state office and says state office means any of the following offices. And there's a list there, right down from the president, deputy president, cabinet secretaries, members of parliament, judges, magistrates, members of constitutional commissions, holders of independent offices, governors, deputies, members of the county assemblies, and so on. There's a list there, but importantly, at the end, there's a category which states an office that is established and designated as a state office by national legislation. So any of these offices, the holders of the offices at a particular point referred to as state officers. Now, these are the people that primarily Chapter 6 deals with. That last one, an office established and designated as a state office by national legislation, is very important, because what it means is that Parliament can increase that list of state officers. Now, the other important thing to understand is that under the same constitution, Parliament is given the power to make Chapter 6 applicable to public officers who are not state officers. So who are public office in terms of Article 260 means an office in the national government, a county government, or the public service if the remuneration and benefits of the office are payable directly from the consolidated fund or directly out of money provided by Parliament. So basically, that's the wide spectrum of public officers. So the net effect is that under the Leadership and Integrity Act of 2013, Parliament has extended the provisions of the leadership, the Chapter 6, the Leadership and Integrity chapter, to cover public officers who are not necessarily state officers. So now we go back, having understood who is covered, we go back to looking at Chapter 6, and we start with Article 73. Article 73 deals with responsibilities of leadership. And it provides that authority that is assigned to a state officer, is a public trust, that's very important, and is to be exercised in a manner that, one, is consistent with the purposes and objects of the Constitution, two, demonstrates respect for the people, three, brings honor to the nation and dignity to the office, and four, promotes public confidence in the integrity of the office. And B, that it vests in the state officer the responsibility to serve the people rather than the power to rule them. So the Constitution requires state officers, and by extension, public officers, to recognize that the responsibility that is placed upon them is not a responsibility to rule the people, but a responsibility to serve the people. 73.2 then goes further to set out the guiding principles of leadership and integrity. And these include A, selection on the basis of personal integrity, competence, and suitability, or election in free and fair elections. So two very important bases on which selection to the office of state officer are based on selection on the basis of personal integrity, competence, and suitability, or election in free and fair elections. B, objectivity and impartiality in decision-making and in ensuring that decisions are not influenced by nepotism, favoritism, other improper motives, or corrupt practices. C, selfless service based solely on the public interest, which has to be demonstrated by 1, honesty in the execution of public duties, and 2, the declaration of any personal interest that may conflict with public duties. D, accountability to the public for decisions and actions. So those who govern are required as part of their obligation under Chapter 6 to remain accountable to the public for decisions and actions. And finally, discipline and commitment in service to the people. Those are the principles of leadership and the principles of leadership and integrity that are set out in Article 73 of the Constitution. Article 75 deals with what conduct is required of state officers. 75.1, a state officer shall behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids A, any conflict between personal interest and public or official duties. B, avoids compromising any public or official interest in favor of a personal interest. Or C, avoids demeaning the office that officer holds. And then it provides for penalties where those provisions and other provisions in Chapter 6 are violated. And I think the most important provision there as regards the consequences of violating Chapter 6 is to be found in Article 75, Subarticle 3. A person who has been dismissed or otherwise removed from office for contravention of the provisions specified in Clause 2 is disqualified from holding any other state office. That shows the seriousness with which the framers of the Constitution held this, albeit short, chapter in the Constitution. Article 76 deals with the financial probity of state officers. And this basically is, first of all, the provision that a gift or donation to a state officer on a public or official occasion is a gift or donation to the Republic and shall be delivered to the state unless exempted under an Act of Parliament. Now, the Leadership and Integrity Act of 2013 provides obviously some exemptions to that provision, so that if, for example, a state officer attends a function and is given a cultural gift like a goat, that would not be covered. He wouldn't have to surrender that. But the exceptions are set out in the Act. But other than the exceptions, 76.1 requires that any such gift becomes a gift to the state. 76.2, a state officer shall not A, maintain a bank account outside Kenya except in accordance with an act of Parliament. So there are provisions in the Leadership and Integrity Act which the exception basically is that a state officer who has reason that they want to maintain a bank account outside Kenya would apply to the Ethics and Anti-Corruption Commission for permission to hold such an account. Otherwise, it is a violation of Article 76. And a state officer shall not seek or accept a personal loan or benefit in circumstances that compromise the integrity of the state officer. Article 77 deals with restrictions on activities of state officers. A full-time state officer shall not participate in any other gainful employment. Any appointed state officer shall not hold office in a political party. Note that that restriction is only as regards appointed state officers. So elected state officers are at liberty to hold office in political parties. And there is a restriction where in 77.3, where a retired state officer who is receiving a pension from the public service or from public funds shall not hold more than 2 concurrent remunerated positions as chairperson, director, or employee of either a company owned or controlled by the state or in a state organ. Article 78, citizenship and leadership. First of all, a person is not eligible for election or appointment to a state office unless a person is a citizen of Kenya. But in the same Article 78 has created certain exceptions where the state office is either as a judge or a member of an independent commission. So those can be appointed, notwithstanding that they are not citizens of Kenya. The other category of person who can be so appointed is any person who has been made a citizen of another country by operation of that country's law without the ability to opt out. I remember a few years ago, there was a matter that came before the courts where the president nominated an ambassador, and Parliament took the view, because this ambassador or ambassador designate was or had a dual nationality, because she had been born in the United States. Parliament took the view that it would be inappropriate and in a violation of the Constitution for that person with dual nationality to be appointed as an ambassador to represent Kenya. But the High Court of Kenya took a different view. And one of the reasons the High Court of Kenya took a contrary view and allowed that the person could take up the appointment as ambassador was precisely because, in the view of the court, the person in question having acquired U.S. citizenship by virtue of being born there, the court took the view that that was citizenship that they acquired without the ability to opt out, and therefore, to cut a long story short, the person in question was able to take up the appointment as an ambassador from Kenya, notwithstanding the primary provision in Article 78. Article 79 of Chapter 6 provides that Parliament shall enact legislation to establish an independent ethics and anti-corruption commission, being a commission of the status set out under Chapter 15 of the Constitution. This, of course, was done by the Ethics and Anti-Corruption Commission Act, and this commission has basically wide-ranging powers to ensure that there is compliance with and enforcement of the provisions of this chapter. I, a little earlier on, made also reference to the Leadership and Integrity Act, which was passed by Parliament pursuant to Article 80 of the Constitution, basically to provide procedures and mechanisms for the effective administration of Chapter 6 and to prescribe penalties and like I said earlier, to provide for the application of Chapter 6 to public officers as opposed to just state officers. And of course, to make provision for the promotion of the principles of leadership and integrity that are referred to in this Chapter 6. In concluding my reflection on Chapter 6 of the 2010 Constitution, I think I would want to offer the view that this is as we look at how effective the 2010 Constitution has been to serve the people of Kenya up to this point. I think this is one chapter of the Constitution that Kenyans need to reflect on very thoroughly to answer the question, to what extent, remembering, as I said at the beginning of this reflection, that the Chapter 6 to respond to the experience that the country had from the time of independence to the time of the promulgation of the Constitution, especially in relation to such things as corruption and bad governance. So I would offer the view that it is appropriate that on this particular chapter, Kenyans need to take a hard and honest reflection. To what extent has Chapter 6 of the Constitution and the legislation that is was passed by Parliament pursuant to this Chapter 6 and in particular the EACC Act and the Leadership and Integrity Act, to what extent has that collection of laws assisted the country to tackle issues of bad governance, to tackle issues of corruption, and to inculcate a culture of the values and principles that are set out in Article 10 of the Constitution, particularly integrity, accountability, and all the other values that are set out there. And if the conclusion is that this has fallen short, then the question must be asked, is there or is the shortcoming in the content of the Constitution and the laws that have been pursuant thereto, or is this a question of ineffective implementation of the Constitution and the laws, or do we need to focus on enhancing, building the culture of constitutionalism in respect, particularly of around this issue of leadership and integrity, the culture of constitutionalism that we referred to in the very first one of these reflections. Well, that is a work in progress, like our reflections are. And I hope at the very least that our thoughts are provoked to answer those questions asked to why, if indeed that is the case, this chapter 6 and the laws made thereunder has not delivered what the expectations of the people of Kenya were in writing and adopting this constitution. I will leave it there for now, and I thank you very much once again, and I look forward to our next session as we continue with these Katiba reflections. Thank you very much.